Вот спасибо. Итак, я объявил тему. Вы видите перед собой основных докладчиков, спикеров. Наш круглый стол двусторонний. Его организаторами выступает Германский фонд международного правового сотрудничества и исследовательский центр частного права при президенте. Ну, цель круглого стола, я думаю, совершенно конкретна. Вы знаете.
I'm glad to welcome you at the round table. You know that we're reviewing our civil legislation, and Mr. Makovsky said that 7 laws have already been adopted. I beg you to sit down because we need to start the discussion. We're wasting time. You know that we have very few things to be done. We need to adopt at least 3 laws to complete this civil code renovation, and we're talking about property rights and the general part as well. Today we'll try to discuss the property rights and use the results of this discussion to work on renovating the civil code of the Russian Federation. There's no need to talk about property law being the foundation of the market economy, foundation of the modern and contemporary money and commodity exchange. Talking about dispositive optionality and imperative in the civil law. It has less to do with the property law, but still. It would be great to discuss the system of property rights, a system of property rights not in the historical perspective, but rather in the today's situation. What should this property rights consist of to make market economy function properly and to make it solve its main goal, be good economy for each country, for the citizens of the country, and for their rights to be represented. We have a great panel today. I think we'll compare approaches to the property rights in the Russian and German legislation. Since we have a bilateral roundtable, our speakers are Evgeny Sukhanov, head of the Civil Law Department of the Faculty of Law of the Lomonosov State University in Moscow. I don't see Anton Ivanov. Roman Bevzenka, head of Private Law Department of the Supreme Commercial Court of the Russian Federation. Professor Hans Pruting, professor in Köln. Professor Berling, Dr. Berling, presiding judge in the Bremen Higher Court. Richard Bock, a notary, vice president of the Federal Chamber of Notaries of Germany. And Andreas Lukov, head of International Real Estate Finance Association of German Banks. So Anton Ivanov is here. We have all the speakers present, and each presentation should not take more than 20 minutes, and after that we'll leave time for discussion, for Q&A. And our first speaker is Professor Sukhanov. Well, dear colleagues, I'd like to thank the organizers for this for this honor of opening a second roundtable discussion, and it's great we're having our discussion together with the German colleagues, because the property rights theory comes from the German law, and I hope will exclude all the theoretical debate, because we still have this debate on the notion of property rights and the system of property rights. I think that European continental experience provides us with all the necessary information on the matter. I have to say that not only our students, but students from Germany and from Austria are less familiar with Tibor, with the name of Tibor, as one of the founders of the property rights theory. And our students start to forget Venediktov's name, Anatoly Venediktov's name. But these two names are very important for our property rights theory. Again, I think I don't need to talk about the essence of the property rights, where it comes from, but get to the current issues. Evgeny Fedorovich is right, saying that improvement of the second part of the civil code on property rights is in the center of this reform. Alexander Lvovich will support me. We know that 90% of objection was referred to legal entities, and once the first reading has passed, we started to get comments and recommendations on the civil code. It's one of the central issues for Russia. It's not only a legal matter, it is also a matter of economy and politics. And this second part was not so easy to put together. In 1994 it was frozen by the State Duma, and it came into force only in 2001, right before the new land code was adopted. I mean, it's new, but it's a typical Soviet law. Talking about contract law, I cannot agree that it is still Soviet, but this land code only left the right of ownership and the right of tenancy, and a few words about servitudes. It turned out that we don't need anything else, so it was a very old-fashioned kind of a code. With civil legislation evolving and the project of the law that was prepared, we tried to get back to the classical approach. And this is what the reforms we're talking about boil down to. In the second section of the second part of the civil code, and we're still unsure about what this second section will be. Hopefully in autumn our legislation will put it to the next reading, and even our legislators now realize that this code is of paramount importance, not contract law, but property law and land law. I'm not sure that our legislators will be working hard, and we're not sure that this code will be ready for the second and third readings. Working on the fourth chapter showed us that the outcome was not what we expected it to be, or we had expected it to be. There are three main aspects that have been noted in the concept: a system of limited property rights, because in the Soviet times there was no idea of immovable real estate. because we have nationalized land, and in these circumstances, immovables and property rights were not needed by the current social and economic system. We forgot about these areas of civil law, and it all boiled down to the property right. We did have two kinds of two rights. We call them property rights. I mean the right for economic management. I sympathize with the interpreters. I don't know how they're going to interpret it. There are ways to interpret it into German and into English, because these kinds of rights are very difficult to translate. I mean, the idea is lame, because land plots cannot be the object of these rights, but we have rights, I mean land rights for the legal entities, and other type of property, other types of immovables cannot be object of this legal entities right. So it's a big problem we have with these two kinds of right. Since we still have those unitarian enterprises, we still need to provide for the management of these land plots they own. It would take me a long time to explain to my foreign colleagues what these legal entities are about and what this property right is. It's not a property right in the proper sense. That's why it is provided for in the 216th article of the Civil Code, Article 216. This is the article providing for these two rights. In the concept, there's a proposal to combine them in one operative management right. The second problem is to provide defense of the property defense. For 150 years the debate has been going on what is the ownership right, what is property right, what is the difference between these two, and I guess it's an abstract issue. We have defense of property. We defend it. We need to put it down into the code, like they do in the Eastern European countries. They have it in the Czech Republic, in Poland, in Hungary. There's nothing to argue about. And the third aspect is defense of property rights. In the Soviet times, we have all the property rights extended to all properties, and everybody, I mean those who everybody who has this or that kind of property can defend their right using using property claims. Once I have been told by the German colleagues that it has no meaning in your law. Your defense should be all the same for all types of property. So these are the aspects, three novellas, innovations that we would like to reflect in the legislation. Our main problem that I would like to focus on. The first problem, it does not even fall under civil law. It's a question of its compliance with the land legislation. A land code of 2001 has to be reformed, has to be reviewed. It does not provide for property rights. It has a lot of civil norms that do not fit into the land legislation. These are civil law norms on buying and selling land, on defending property rights. They are in the civil codes, and all the peculiarities are in the land code. So the highest arbitration court, Supreme Arbitration Court, had to discuss these problems, but I think these problems are artificial. but they reflect actual problems that we're facing. Over 90% of our land, it's public property, state property, municipal property. Over 90%. I'm not calling for privatization, but it's a fact that we have to take into account, which means we have to use the land, land being public property, used by private owners. You won't find it anywhere, neither in the German law. In 9 cases out of 10, the owner is state or public, and the owner of the building constructed on this land plot would be a private entity. And the second problem is a problem of registering property rights, because our register, unfortunately, is not it's not public, and it's not true to the real situation, does not reflect the real situation. We declared the private ownership right, and 5 years after that we realized we should.
In the civil code there was an entry, then the law on registration of rights to property was enacted, then we have to set up the system of authorities registering the rights to real estate, and from 92 to 98 the rights to the land plots were registered by anyone. And now, for instance, I am buying a land plot, being guided by the entry in the register. Sidorov is the owner. I have to agree with him. In 1 year, Petrov will come and tell me that in 1996, the Urban Council, which is no longer existed, issued a certificate to me that I am the owner of that land plot. And we address the relevant norm of the law on registration of the rights to real estate, and the court has to take into account. And we compare the entry in the register with that certificate, which some fraudulent workers of the registering body can copy on color printer. And there were some criminal cases in Moscow region. So the result is quite obvious. That is one group of problems, and thus land legislation has to be improved seriously, so that the norms of the civil law would be in the civil code and would be correlated with registration of the rights to land. However, since 90% of land are state-owned, we have to put it softly, to alter certain classical institutions and approaches. And the second circumstance, which causes a lot of practical debates that I would like to mention as a conclusion, is the nature of the lessees' rights. In the previous time, in Soviet time, without a lessee, if you don't know, is protected one order better than any other owner. He has certain property rights case, and that was in the Soviet time, when the lessee was protected as a legal entity, as a citizen, against the state owner. And in 89 a law was enacted on the law on the leasing, when the state, you can take the property from the state on lease without ever returning it. Just try to make the trick with the private owner. For instance, I take lease property from you, and you might bid goodbye to it, and then I pay its balance value to you, and I become the owner. That's quite nice. And as for the state, that could be done, and all the economists said that is a good way of denationalization that we have invented. So this wonderful tool is used up to now. We are accustomed to build on the land that belongs to the state, and Anton Ivanov said that that technique results in corruption. If that is a public owner, a state servant acts on his behalf, which is currently called an official, and whose interest would be slightly different when this lease contract will or nil has to be extended. Commonly it is concluded for 5 years, and the normal developer will prepare the cost statement and the design documents and will dig out a ditch. Then he has to extend the contract, and the official understands it. And he says, yes, we are going to extend it. For instance, the barley is too expensive and the inflation rate is high. Let us agree about the rent now. Unlike that normal right of development that acts not only in developed countries, but it was also in our country, there was a provision on development of 1912 pre-revolutionary that was well developed, and it acted until 1948 after the revolution. We have just forgotten it. That right of development eliminates all these problems. In Germany it is also well developed, but it infringes certain formal dogmas. So in Germany there is a provision on the rules of development of 1919. It has been transferred to a law now with certain amendments, but it is valid up to now separately from BGB. With us, they say that that is property rights, I mean leasing, and you shouldn't make it mandatory. We mean not only leasing, but leasing of property or real estate. Renting of, for instance, movables or camping devices results in no problems about property rights protection. Secondly, as for renting of real estate and the nature, that is a history-long, century-long history. I would like to cite Gabriel Shershenevich from his reference book on civil law, where he wrote that there is a constant struggle between the legal logic and the interest of the lessees. It reflects all the legislations which commonly have difficulties in solving the problems when the lender and the owner changes. He is the owner. He is not bounded by the lease contract, so he might demand that house or land plot, and he has to compensate the losses to the lessee. However, Gabriel Felch's right life counterposes that logical statement, being afraid of the interests of the renters and leases, who under such legal implementation might be deprived of their houses and land plots into which they have on which they have labored. So some legislation would like to recollect the rule, the right of following. So there was a proposal in the pre-revolutionary draft of the Civil Code of the Russian Empire. Of course, renting or leasing in the German law, these are two different institutions. Property hiring or rent are rights of obligation, not property rights, because the scope of the rights of the lessee might be determined by the contract. For the property rights, that is impossible. Even property right protection, and these are not the main features of the property rights, but the circumstance that some for instance, renting of real estate, the law adds some property right elements, and as to the legal nature, it doesn't change the legal nature. According to the civil code, draft civil code, if the lessee of movable property changes, he might demand termination of the contract, but if of the immovable property changes, the hiring agreement registered in the register became mandatory for each new acquirer of property. That is the procedure followed by other legislations, including the law of Germany, and I think it will be useful for us to listen to our colleagues, because the famous principle, Kaufpflicht nicht Miete, purchase doesn't break the sales, and alienation doesn't break the hiring relations. Even in the German law, as far as I understand, it concerns not all types of rent, but lease of property or real estate, provided there is an adequate interest of the buyer of the object. For instance, an apartment who wants to use it for his own needs, he might cancel the agreement if it is concluded for an indefinite period, even according to the German law. Similar norms are assigned to the legislation of Switzerland, France, and other developed legal orders. And here probably we have to state that for lease contracts on property for which SMEs, are very much concerned. For instance, office premises, apartments belonging to them, we might make a withdrawal. No one would be against. But as to the legal nature of rent, it doesn't change it. Rent is an obligatory right, and that is one of the problems that causes ardent discussion, because our business and the servicing lawyers are very much afraid of it. And I think that their fears are lost in vain, because even in the draft document that might be subject to the second or third reading, there is a possibility of choice. Not only the right of development, you might continue the lease relations, or okay, if you want to develop it, okay, but we are not accustomed to we have become not accustomed to development for many years. We have to introduce a normal system of restricted property rights, and I'm sure that sooner or later life will demand a resolution of these problems, and reform of the land legislation, introduction of the system of restricted property rights, because turnover of the land plots is a very serious thing, and without limited property rights we won't be able to do. When our legislator will be able to solve the problems, unfortunately we are not responsible for them, and I think that we have done our job in the development concept of the civil legislation in that draft law. Thank you for your attention. Good afternoon, dear participants of the forum. My presentation will be dealing with the relationship between the principles of property rights with the system of state registration of the rights to property and real estate. Professor Sukhanov in his presentation stressed that the difficulty of the fate of property rights in Russia was due to the events related to October Revolution of 1917. However, in my view, this is not a complete picture of the situation, of the phenomenon which we're facing. Actively in Russia, there were never a strong system of property rights existed for everyone. Because if we go back to the history, the guarantees of property were received only based on the order of Catherine II, and it was granted to nobility. Neither peasants nor other representatives of the citizens could have stable property rights in the Russian Empire. Moreover, land plots assigned to land owning by peasants were always changed and divided within the community. It is also interesting to note that the land owning by nobility, though it was guaranteed in the Russian Empire, was never complete and really existed from the economic viewpoint. Since the peasants has the right to use the lands of nobility, often to a much greater extent than the land plots used by the noblemen themselves. So there were no full-fledged property rights in our country. They never existed, I mean the rights for everyone. So naturally, the promotion of the system of property rights in the draft of changing the civil code is facing such serious objections. I think that all those who are present here, I mean the speakers, the panelists, representatives of Russia, we are adherents to the continental system of property rights. And I believe that for our country it would be quite beneficial if we implement them. However, I realize all the difficulties that we might come across along this trend. And I believe that the main difficulty which kills the advantages of a developed system of property rights following the German model is our state registration of the rights to property and transactions therewith. Because the system of registration which is available in our country doesn't provide any state guarantees to the holders of the property rights who are within that system. We cannot say that guarantees a payment in the amount of 1 million rubles to the owners of their partners who were deprived of the right in the register. I don't know even a room in a communal apartment at present, and that is also our object of property rights. Unfortunately, it doesn't cost million ruble, it is much more expensive. And to say nothing about other objects. However, the amendments approved to the civil code make us doubt whether this million, even this million, will be paid, provided there is no guilt of the public authority dealing in registration, because the amendments that have already been made restore the principle of responsibility for the guilt. So that million in principle can be most likely received if it has been proved that the registration body is guilty. No such cases are available, despite the fact that there are a lot of misuse in the activity of registering bodies, but such suits are not brought to the court of law. I would like to stress that the continental system of property rights is efficient only in combination with a system of state guarantees provided to the holders of these rights. And I'm afraid that our state in near future and foreseeable future will not be able to provide such state guarantees. And now I will try to provide the grounds for this statement. Sometimes I am asking our colleagues, judges from Germany, do you have a lot of cases when the state compensates to the persons deprived of the rights to property resulting from some entries in the registers? Do they often pay some compensations? No, quite few cases, for instance 5 to 10 cases per annum, and that's all. In Moscow only, simultaneously we have up to 1,000 court proceedings a year where property was stolen in a fraudulent way, up to 1,000 cases. Just imagine the amount of the compensations to be paid, and it will be quite obvious that our state will never pay this money until the general level of corruption reduces in that sphere, until the amount of the compensation will be bearable for the state and will be quite moderate. And I cannot see any prospects at this time so that this process would evolve. Without state guarantees, without public guarantees, the system of registration, provided there are stringent property rights and mandatory cadastre registration of property objects, will be a severe burden for the private individuals that doesn't grant any privileges to them. Actually, the state wants a private individual to draw up the taxation object for the state, offering nothing in exchange for that. And each year, new rules and regulations are introduced concerning drawing up such documents, which are a severe burden on the owners. I will just give several brief examples. First, they issued the property certificates on the decree of President Yeltsin without cadastral plans, and all the people have received them, drawing up the relevant documents. And they said that these certificates were not valid, and they required to draw up the cadastral maps with topogenetic correlation to the land plot. Then they had to prove on the permitted use of the land plots and the borders of these land plots, which now are not approved in 80% of cases. What else will be invented so that the private owners will have to agree on them at their own expense? But I'm sure that something will be invented for sure.
Because unfortunately, certain public officials are interested exactly in that. They really create barriers for the land users and other property objects, not to mention the cadastre plans, which are to be updated every year. For 10 years by now, this has been happening. Every single year, people have to update their information about their plots of land and the property on the land. Actually, the system that exists is quite burdensome for the property owners and doesn't provide them with any privileges. Well, of course, this could be all right if the state was providing compensation equal to the market price of these sites and these objects. If due to the fault of the public authorities, you lose this property and it goes into the hands of a third party. And even within the torrent system, the well-known torrent system, this doesn't always work. But in the present-day situation, unfortunately, I more and more tend to believe that we should really get rid of this cadastre system and rather register transactions typical of the Anglo-Saxon format, which are not that burdensome for the users, for the land users, but they're risky from the point of view of the title and checking of the title. But in our system, we have to check the title every single time we buy property. So our system does not differ that much from the system of transactions registration, because it contains exactly the same transaction costs as the system of the registration of transactions. But with all of that, there must be registration of the rights of the title, cadastre registration, and other costs associated with the respective system. So it might look strange, but I do believe that this transition would help to protect the interests of the individuals, although it is believed that the system of registration of the title provides less guarantees than the classical system, the cadastre system. But under our conditions, it might lead to a reduction of the costs for the individuals, and I cannot see any prospects for the change of the existing system. So I don't think that the state is willing to take upon itself all the losses associated with the loss of property. And there's no hope about that at all. That's the first thing I wanted to mention. Secondly, it's interesting that our system of land rights, which we have at present, is very similar to the English system of titles, relevant titles. And I cannot say whether the American experts took part in the development of our land code, but nonetheless, it's very much like the model that we can find in the Anglo-Saxon law. Namely, there are titles on land, and according to the law on the land registration, if they are in the register, then there are better and higher guarantees as compared to the unregistered titles, but unregistered titles are also recognized. So it seems to me that it's very similar to what we have today in our system of land law. And this example is the example of a situation when the Anglo-Saxon law covering land title, has found roots in Russia. And why? Why do we like this system so much? Why does everyone like this system? Now, first of all, it complies with our national tradition, as we do not believe that there are short-term titles for property. And the sources of these traditions are in commune psychology and the position of the state exercised over the past centuries. That was number one. Then secondly, we liked in these titles the dependence of these titles on the wish and will of the public authorities. It's wonderful indeed. What can be better for a bureaucrat than this? It's all is at the discretion of that official. That range of discretion is very wide, and nobody can limit this range. So it's a wonderful environment for this sort of work. And then this model is also preferred by the individuals. Why is that so? Let me explain. Our business, unfortunately, is built on the short-term approach. The legal entities have a very short period of existence. They seem to be changing over time. This entity has been soiled. Let's create a new one. The second one is soiled, so to speak, and they move over to the third one, and again it is going to be soiled. So that's the philosophy. And there is an exception, of course. There are large companies who are very much interested their capitalization for the listing, and they really have to carry out this work carefully, and so they cannot be at all criticized for this sort of thing. But the titles on land in this structure are very convenient, extremely convenient, these relative titles. First of all, from the point of view of taxation. Definitely, taxation in the process of the alienation of property right is very different from the situation when the obligation changes the parties. Secondly, it's a less formal procedure. Third, it's a speedy procedure. It's very easy to transfer assets from one structure to another, which is very convenient for these individuals because the tax inspectors are right behind them, and they really have to transfer their assets. So this is a rather sad picture I have to draw. But all this makes the system of relative titles on land popular in the Russian practice. Well, I do believe that this system must change, and we have to change the methods of business which predefine the existence of such a system, and the public authorities should lose the right to exercise this type of approach when defining the volume of title. It should never be arbitrary. And when we try to explain all this to the business community, they will inevitably ask a question about the costs associated with the registration of right and the absence of guarantees. So, well, okay, you propose property right, but what can we do about that? So it's easy to lose them. It's easy to lose them, as easy as to lose the relative rights, and the alienation is another issue to be considered here. So it's a basic contradiction that exists under conditions of Russia. So we are actually prisoners in this particular sense, the prisoners of this contradiction. And I don't, frankly speaking, I don't see an easy way out, an easy solution. We really have to choose what we want: strict formality, strict guarantees, and we want to be sure and certain, and then of course the guarantees are provided by the state through the system of property rights and through the guarantees to the individuals for their rights. Or we make this whole system of registration less formal and reduce the transaction costs for everybody involved. And I don't see any other options. But we don't know what the legislator is going to choose. And when Yevgeny Sukhanov spoke, I could see that some of the participants were smiling when we spoke about the property character of rent, reduction of... well, I can explain to you why I think all this is so important. It's important following the principle of registration and entry, because the rent contract at present, as a document establishing the right and is part of the register, public register for property rights, but it's the part of it that is not public, and it will never be possible to find out what the conditions for the third parties are within this contract, rent contract. Only law enforcement authorities and the right holders can find this out, and if they file in a special request. And respectively, the conditions which provide the termination of this contract are also not known to anyone, because the burden is associated only with what is registered. But we have here a somewhat strange rule and a game with unknown components. And there is quite a number of very peculiar cases. For example, an individual acquires business, and there are rent contracts attached to that, and then the rent elder actually absolutely refuses to follow the obligations. And does this comply with the principle of the public registration of the property right? Does not comply at all. And for these particular reasons, I believe that we should make the property character of the title weaker. Not dealing completely away with that, not doing completely away with that, but we should make these rules somewhat less stringent and strict. That's it. That's what I wanted to say. Roman Bevzenko, head of the administration for private right of the Arbitrage Court of the Russian Federation. Thank you very much. Dear colleagues, there will be a presentation, and I will refer to my slides. Allow me to comment on some of the ideas that are associated with the project or the draft of the property right within the civil code. The right for development is being restored in the code. I'm talking about restoration, indeed. I'm using this term because one of the popular arguments we can hear from our colleagues indicates that they do not believe that there was ever any right in Russia to develop, indeed. But this is not true, because the right for development existed in Russia. The law was adopted in 1912, and in the Civil Code of 1922, these provisions also existed, and they were there until 1948. So for half a century on this land, the right for development existed. And allow me to say that any educated person in Russia is familiar with this right, thanks to the to Bulgakov's novel, The Master and Margarita. And here is the quotation from this book when the main character, Master, explains to a homeless poet what developers are. He says that developers are the frauds, a small group of fraudulent people who have somehow survived in Moscow. But this is a negative attitude to development, of course, but this is predefined by the subject matter and by the story that is told in the novel, but not told by the legal meaning of the term at all. So let's talk about the essentials. It is quite obvious that when a person is building, the person can build either on his own land or on someone else's land. In order to develop one's own land, one can exercise two opportunities. You can build on one's land because you have a contract with the landowner, and this is the basis of your operations carried out on the land. This is the contract. And there is a second option. You build on someone else's land because that is the burden associated with it. The owner agrees to suffer your presence there while you're building an edifice, let's say. Thanks to this situation, there is a certain need to introduce this notion into the Russian law. First, we sign, as a rule, the contract, the rent contract, for 3 to 5 years, and the tenant registers the right of ownership on the building to be constructed, and then he goes again to the landowner with a request to sign another contract, the contract for the purposes of the exploitation of the land plot. Now, why is this system criticized? Well, it's obvious that this right for someone else's land should have two qualifications. First, I would say that it's the stability of the legal status of the developer, of the one who builds on someone else's land. How this stability should be expressed. There should be at least a long-term period of this right, of the existence of the right. Then the developer must be absolutely sure that this contract cannot be terminated unilaterally by the landowner. Then he needs to be sure that the payment for the this plot of land is not going to change, the rent is not going to change, and then the possibility to sell and to pledge the right is very important, and I would like to speak about this in more detail. This possibility and opportunity to pledge someone's land which we develop. Now, the one who builds on the strange land practically never does it with his or her own money. Usually, it's the money coming from the bank crediting the construction, or it's the money of the investors involved in construction. It seems to me that one of the main problems that we face in Russia is the problem of the fraud against the owners of apartments. Usually is the fact that the developers do not build on their own land. They build on the land rented, and they do not have proper assets which can be pledged in the bank. The collateral, proper collateral cannot be provided for the banks. That means that the developers sign contracts on sales contracts on the facilities that are under construction. We have practically no bans here on involving private investors into that. And so if the developer turns into a bankrupt, then everyone involved in this particular enterprise face this risk of the developer's bankruptcy. In case the funding is provided by the banks, then of course collateral is needed, and the best collateral is the land right, the title. But usually the developers do not own land, and the construction rights on the basis of the rent do not create any possibility of providing a proper collateral for the banks. And usually there is an easy way of changing the content of the rent contract by one party, and usually the transactions can be recognized as void quite easily on the basis of many of these approaches. I talked to many of the lawyers who work in the banking sector, and they say we accept these documents as collateral only if we understand that there is goodwill on the side of the developer, that there is reputation, there is in the field of construction, and we understand that this collateral is just a figure of speech. Indeed, it doesn't cost anything. We, the developer actually pledges reputation, but not the right on someone else's land at all. So, and finally, it seems to me that there is one other problem associated with the doubling of the procedures. And this inevitably leads to higher costs. When we say then we first take land for the purpose of construction, then have to get the property right on the building, and then the third step is to have another rent contract, so that my building built on someone else's land has a legal ground, so to speak, and is not hanging in the air. So I do not want to speak about the second element of the structure associated with the rent under the building constructed. This is quite a strange situation indeed. There's an elementary matter here. Is it possible to terminate this particular rent contract signed for the purpose of construction if you are not paying? Now, if you take the norms of the civil code, code, and then it's possible. But then what is going to happen to the building? It's not going to take off and fly somewhere else. And the application of the rules on rent following Article 36 of Land Code provoke a situation like that. And the Presidium of the Arbitrage Court actually once tackled this particular matter. Is it possible to carry out this particular operation if there was a 2-month delay with payments and with the rent payment? And I understand, of course, very well the judges there who said it's impossible. It's impossible to terminate the contract, the rent contract, but the Presidium acted conservatively and said it was possible, although it seems to me that it's a legal dead end. The rent contract should be for a long period of time, and normally it is for a long period of time and does not envisage any remodeling, and the right is established once and for a long period of time, for the whole period of time of the effective existence of the building put up on someone else's land.
And finally, there's one very important issue we should talk about. Maybe there's no sense in introducing new structures, but use rent, but renovated. Introduce a paragraph, rent for building, and combine these two articles, both building tenancy and rent. Provide for minimum terms. It could be an option. It would be better than the situation we have now. But in fact, I don't find it right. And judging from the method, when we use these tools that allow you to build on someone else's land plot, we call it rent. I know that many would try to project their contracts for rent on this kind of situation. If we have one type of rent, first rent or second rent, you have rent or right to develop, right to build on a land plot. I don't see a big problem in introducing this kind of law. And the last thing I wanted to mention, or to introducing a right for development, would probably encourage an idea of the so-called unique land plot and creating something on this land plot. I think it would be strange to discuss an idea of if you build something on a land plot, then this building is part of your rent and you don't need to register it. People go and register their ownership right for this building. One resource extracting company told me some facts. They say we spend hundreds of millions of rubles to register ownership right for the structures, for the for the facilities, but we don't understand why the state would make us register ownership right for these facilities. If we had this, development right for this land plot, that would be all our costs. I mean, hundreds of millions of rubles could be saved without having to register, and we'll keep this. We could keep this money in the company's budget. And if we think of a building as an immobile, not as real estate, it could be very important to introduce this into legislation. A right to develop would be part of the legislation, and it could be sold and bought. Another issue, I'm even afraid to talk about it, about the limited terms. You buy this development right, you have this building which only lasts for 100 years, but I mean it's finite. Either the person who buys this right or the building, it will eventually be demolished. if we think about the so-called Khrushchev type constructions, I mean, houses that were built to last for 25 years, and now they're being demolished. And it was a popular subject in Moscow. How do we renovate those houses? Friedrich Larengoen said that this speedy development has to do with technologies evolving, and housing becomes more comfortable, and you need to demolish the old ones and build the new ones. We're talking about, terms of 100 years. Those skyscrapers in the city, in the Moscow city, how long will they last? We can find compromises. Maximum term would be 100 years for development, or 150 years. It's not a legal question. It's a question of how we treat technology. And to support my idea about this right for development, it's a letter that the landowners who wrote a letter to the State Council of the Russian Empire in 1905, and where they were begging to take the side of the oppressed, those who rented this land, and adopt finally a law on building tenancy and secure memory in Russian history. And I think we get back in a way to this historical moment. Well, we understand the motives of the speaker by the end of his speech, of his presentation. Our next speaker is Professor Hans Pruting, professor of the Köln University.
Herr Vorsitzender, meine Damen und Herren!
Господин председатель, уважаемые дамы и господа, благодарю вас за приглашение и возможность выступить перед вами. Я в то же время хотел бы извиниться за то, что могу с точки зрения германского права только в целом описать ситуацию в этой связи. Мои коллеги, которые будут выступать после меня, будут говорить об этом подробнее. Одновременно в то же время я хотел бы вам сказать, что с точки зрения германского права, о котором здесь много раз упоминались, российские проблемы вечного права просто не существуют. То есть это значит, что из моего доклада вы не узнаете ничего, например, о различиях в арендном праве, вы не услышите ничего о владении, например, участком, которое не является при этом арендуемым и так далее. Вы также не услышите ничего о праве на застройку с точки зрения германского права. Напротив, мне кажется, вам будет даже скучно, но мне кажется, я лучше расскажу о том, что германское вечное право действительно сформулировано очень четко и является очень закрытой в себе системой, которая с нашей точки зрения дает довольно большую защиту с юридической точки зрения. Уважаемые дамы и господа, пару специфических слов, специальных слов. В принципе, наше земельное право сформулировано в Гражданском кодексе, которое вступило в 1900 году в силу. Оно делится на 5 книг, и в 3-й книге как раз речь идет о вечном праве. Что касается ипотечного права и прочих вещей, которые связаны с этим, за прошедшее время никаких изменений с этим не произошло. Все это основано на римском праве, и сформулировано ведущими германскими юристами, как Свинит, Бо и так далее. Они разрабатывали это право еще более подробно. Что касается недвижимого права, то здесь, хотя и есть соответствующие подзаконные акты, которые каким-то образом унифицируют, специфицируют право, но это, например, закон о владельцах квартир, закон о пользовании земельным кадастром и о принудительной продаже на аукционе. Мы делим нашу систему на правовые субъекты, правовые объекты и отношения. В рамках объектов мы различаем движимое имущество, к которому относятся только земельные участки фактически, также права. Что касается отношений, они урегулированы довольно четко. Что касается ипотечного отношения, это отношение относительное, и оно относится только к одному из партнеров по договору.
Property relations, they are reflected as relations as ownership relations, and owner is defended from any attempts to obtain their property. An individual does not have a right to execute this principle complies with our own instruments like insurance, and the right for defense. German property law is influenced by three principles: a principle of division and abstraction, publicity, and the principle of certitude. The division means we have a division between property and ownership. We're talking about different types of contracts. A mortgage contract is one thing, but a contract within the property law framework is different. A mortgage contract provides legal basis or causa to enforce deals. That's why we call it a causal deal. This kind of division is reflected in the fact that the property contract is abstract. It does not depend on the causal deal. If property is bought or sold, or a mortgage is terminated, a new contract should be drawn. Property law has an absolute character, reflects the changes which should be obvious for all parties. And the second principle, the principle of it being public, all parties are respected, and the third parties should be aware of that. This public character is very important for movables, and thus it refers to ownership. As for land plots, it is registered in the land register. Transferring ownership rights is not possible without it being registered. Public character also means that the legislator wait for expect a public announcement. Only one object can be a subject of contract, since mortgage contracts and sales contracts say that something is being sold or bought, and then this object becomes the center of the contract, and its property property content of a contract must comply. For example, if you pledge a shop in a bank, you need to describe in detail what property is pledged. Exactly. This brings us to a principle that there are objects that the person is responsible for. You have a right to a land plot. It is noted in the register. Anyone can get access to a register and will see that this is legally clean. The situation is legally clean. It gives you, it assures you of the law being enforced, and investors are sure that they have chosen a right plot with the proper parameters of legal guarantee. If I want to terminate a deal or a contract, it should be reflected in the register. Apart from sales and acquisitions in the real estate sphere, you also have collateral contracts, and in every contract we're talking about real estate property being a collateral for loan.
And there are some real guarantees and realistic guarantees, which this is an object which exists in nature. However, if we speak about the provision with really existing objects, we have to separate it clearly. As to the assessment of the land plots is impossible. That cannot be overestimated. This is a very important factor. The German legislator speaks about the authority of the mortgage agreement. If we take into account that a certain object is taken into account, which will guarantee the rights of the creditor, that is also entered into certain registers on property, and it would not be correct to make any conclusions that only a land plot acts in this role. There is a certain series of regulatory acts which describes what objects can also participate. These might be certain component parts of the land plot, for instance, the trees grown on it and the buildings erected on it. 1120 is an article which states that the supportive contents of the land plot also applies to the objects that are located on it, and that land plot, even after cancellation of such agreement, is still acting, particularly that collateral concerns the so-called material composition in respect of belonging, which belongs particularly to that land plot. All the movables located on it by the entrepreneur, some equipment, agricultural tools, and so on, they form an integral whole with that land plot if it is intended for making agricultural work. So this extrapolation of the legislators results in certain consequences for the lease contracts of the land plot or immovable property on them. Generally, you can see that this provision, in our sense of the word, will be interpreted in an expanded way. That is not only the land plot, but the objects belonging to it based on the function or the use. Allow me to introduce another term, registration of the rights and the legal basis that is created by it. In a common case, each land plot has its own plan, and it is necessary to put it into the register. There are three departments dealing with this. The first department describes the entire property allocated there. The second one records rights, and these rights might be restricted or not. And the third item concerns the mortgage and legal provision and reliability. And in the turnover of the land plots, we have to take into account all these items. There is a coercive necessity or duty to keep these cadasters and registers and to provide that information in public so any person can read it and understand that each land plot has its own cadaster that is kept each year, and property relations are separated from the mortgage relations. That is the support of the rights that leads in a certain system and procedure. Hence, the cadaster can be the grounds for certain crediting terms, and all the rights which are to be registered are passing through a certain procedure and are regulated by paragraph 38 of the Civil Code. That is, no turnover of the land plots without cadastral registration will be possible. The transaction would be unlawful, and the decision on these matters has to be taken. If someone inherits a land plot, the inheritance is not referred to in the cadaster. It is registered in other registers, so this is a specific feature. It is presumed that there is a certain succession of the rights related to the laws on the inheritance, and that provides the workability of the system, and that ensures the necessity of making the entries on these, making these entries into the cadaster entries on the land. If something happens unlawfully, we have to make certain amendments to the cadaster. Thus, the provisional role of the land plots is supported by the cadaster. As an exception, the cadaster can result in a certain gap in the field of the law if a certain transaction is effected for the time framework, in which case not only the statement of the cadaster status is necessary, the cadaster is guaranteed against the contradictions of making changes. And we introduce another guarantee. For instance, the attorneys at law check the keeping of the cadaster. And then ranking. For instance, the land plot might be mortgage, and that collateral will be valid for several contract that is entered into the cadastre, and the succession and level in respect of the importance is also maintained. This is also related to the collaterality. There are some preemptive rights in case of the court proceedings, and in a certain succession the interests of the creditors are satisfied, and then we pass on to another term of coercive implementation. If there are any debts, if the mortgage is not paid, and in our case the collateral of the land plot has to be sold to satisfy the interest of the creditor, when there is a coercive sales of the land plots in the creditor's interest, or the so-called external management in certain other cases. And the decisive issue is coercive sale, for instance, for getting a certain amount of money for that land plot. If coercive sales and tenders are organized, certain rights are infringed. In this case, the mortgage or the rights of the debtor or the rights of the creditor might be detrimented. Here the positions of the creditor might be detrimented, and here the collateral right is developed in the interest of the creditor. And the last term that I want to introduce is insolvency or bankruptcy. Here the property right should be applied for reconciliation of the interests of the creditor and the situation of the borrower. It goes beyond the limits of the right to the land plot with all the movables and immovables. A reconciliatory procedure is also possible, and there is a certain list of and succession of actions. There is a mortgage law and emburdenment of that object that is involved therein. If an emburdenment is imposed on the land plot, we have to apply certain requirements and certain succession with creditors, and the creditor in each case can sell that land plot if it is his turn in case of bankruptcy of the borrower. If the external managers are nominated by the court of law, and if he starts his activities, he will be responsible for selling movables and immovable property. So that is quite often the case. And there is a certain table of requirements and certain articles in the legislation that describe this procedure of setting the requirements of the creditors, and some time of balancing will come. This requirement in the economy is most likely the second version, and allow me to make the following statement. On behalf of the Russian speakers, we have heard that there was a proposal related to practical difficulties and complications of the legal system to not to register the transactions following the Anglo-Saxon law. It seems to me that in connection with such registration following the Anglo-Saxon procedure, we won't be able to protect the rights of all the parties. For instance, many of my Russian colleagues discuss the theme of bankruptcy, for instance, and there will be also some difficulties in that field. I can assure you, I don't think that this will be a correct procedure. Thank you for your attention. Some of the participants are leaving, probably everything has become clear to them already. Those who remain here are still thinking about it. The next paper to be presented by Doctor of Law, Chairperson, Hein Berling, Presiding Judge of Bremen Higher Court. Ladies and gentlemen, allow me to welcome you, and I would like to thank you for the invitation to participate in this forum. Yesterday, I was glad to participate in the round table that was dealing with renewal of the civil code, and then we were saying that this theme will be quite important in that field. I'm speaking about the property right. It was very interesting to listen to the presentation of the Russian colleagues so that we would know where we have to record the notions and clearly use the property right in the economy, and also to learn how much Russia has to do to keep pace with other countries in that field. It was also interesting to listen to the presentation by Professor Pruting concerning the legal guarantees that are attained due to the adequate use of the property rights for all the parties, primarily for those who are subjects of economic activity and for those who are looking for different ways to receive credit. Frankly speaking, thinking about it, I thought that I was going to make a brief presentation, because I always found in all the themes and in all the publications on that theme in Germany, only one statement that the guarantees in Russia are not recognized. However, in the Russian law, there is really no notion of collateral property. However, in Germany, this institute also developed at the wish of the economy. And if we can word it in this way, after the Second World War, when the motive was just chronic underfinancing of the German economy, so we can presume that in Russia, in certain economic communities, there exists or will exist a very strong interest to introduce the new supportive instrument that will make it possible for the economy to use other resources. In one of the previous presentations, we have heard that 90% of property do not belong to private economy, so they cannot be used as collaterals. As for such property in general, that is an instrument using which movables can be transferred to the creditor as a collateral for certain credit, and that can be used in these purposes only if a person who has taken a loan is not able to fulfill his obligations under the contract. As to the property rights, the creditor is a limitless owner of that particular object. However, he cannot lose this property related to his agreement with the person who receives the credit. All this acts up to the onset of the so-called case of collateralization. This is not worded in this way in the law. However, this harmonizes with the current laws in Germany. If we analyze the Russian laws, you will see that in your civil code there are all the ingredients for introducing, according to your own law, the collateral law for the real estate. As far as I understand, in Article 307 of the Civil Code, there are the statements stating that you can use a property for this purpose. You also have the closest relative of that property in the Civil Code, that is a reservation on the property. So the situation when the seller keeps the right to the commodity until the buyer has paid the entire amount and fulfill all the terms of the transaction. That is Article 491 of your Civil Code. If you analyze that institute even more attentively, you will see that there is a mirror reflection from Germany. Two institutions are closely related and correspond to each other. And according to your legislative system, nothing contradicts the facts to recognize that collateral right on real estate in Germany. There was a very serious battle for that institution. It was called just a child of the authors of the Civil Code, born to the parents who were unmarried. All the battles against the collateralized property were lost. That was a battle with the windmills, and I think this question will be solved with time in Russia. In Russian publications, we can also find similar statements in respect to numerous clauses of the property rights, that is freedom of contract, which we know in legal norms that describe the right of the debtors. They do not apply to the property rights directly, and that is the main reproach formulated by those who are against, who were
against the security measures. And we explained to them that in German law and in Russian law, there are all the ingredients, as I said, for the introduction of such an institute, which are envisaged by legislation. So you can say that the security and the mortgage right does exist in Russia. Our colleague Sukhanov writes in his book of 1995, apart from other things, he speaks about the property right, and I can see here that we can definitely say that in compliance with the Civil Code of the Russian Federation, we can accept this particular institute as an existing phenomenon. Now, in the transition countries, which began to change their legal system after 1989, trying to introduce continental law. They introduce certain spheres and certain aspects of legislation that we are not that familiar with. Well, of course, we can speak about property rights and we can speak about chattel, but we do not have to introduce any of that because we have two other instruments for guarantees. That's mortgage and pledges. And I'm not going to speak about all of these in detail, but the pledge documents are more abstract and are being used quite often. In other countries, this is not being used. In other countries, mortgage has become prevalent, and we do not use this particular instrument that often in real life. And contracts can be signed, so a bank signing this contract with an individual can sell this or that object or this or that collateral if the amount is not paid back. So it's a sort of a camouflage. We're not saying right away what the instrument means and entails, but the loan must be secured. And I know that there are serious problems, and I know that this instrument is going to be introduced in Russia, and I'm quite sure Russia is going to face problems similar to what we have. Let's take the example of Georgia, which I mention because the Georgian law system contains a lot of the provisions we can find in the German law. Difficulties emerge in connection with this particular instrument. So these difficulties do exist, but with the help of the new civil code, you will see that the requirement for registration is going to be very strong, whether you register contracts or some other documents, or we can suggest registration of property. Then the contracts will contain exactly what is meant and not at all what is presumed. If we don't do it, then the contracts become void in compliance with the respective article, and what the parties presume is also not fixed in the contract, and their will and wish is not protected by any provisions of the law. As a result, the legislator cannot the creditor cannot rely on the contract, and the borrower is in a better situation borrowing money. Well, of course, the bank signs a contract like that just once and never again. And exactly because of that, it's very difficult to get a loan. If documents register what really exists, then it's much better indeed, because then this information can be relied on and we have dogmatically clean structure. The structure covering the property rights, and well-educated notaries can successfully keep the register. If everything is in the documents, of course, and then the court can rely in the decisions can rely to the documents and refer to the documents. This concerns businesses and individuals, and as you know, your legislation covers individuals and businessmen. Banks are trying to say that if a loan is not returned, then the collateral turns into the property of the bank. An old phenomenon, edict issued by Emperor Constantine, who stipulated that the transactions in which the security disappears and changes hands and becomes the property of the creditor. That's indeed well known. So it's a problem we've had for years, centuries. Thank you. Now, time flies. We don't have that much time left at all. Allow me to give the floor to our next speaker, who is Richard Bock, notary, vice president of the Federal Notary Chamber in Germany.
Уважаемые дамы и господа, уважаемые коллеги, во-первых, мне бы хотелось выразить радость от того, что меня пригласили на это мероприятие.
It's a great honor for me to be here in St. Petersburg again. It's my third time here, and I can say that it's a good tradition of mine. The city is beautiful, and presentations made at this forum are most interesting. And indeed most important for the invited professionals. We come here not just to talk to you about something, about the legal system at home, about the practical application of laws in our countries. We go back home enriched with new knowledge, new experience, because we learn from you how to overcome difficulties. We learn from you about your legal system, and we understand our role and our mission in exactly this way. We're here not to give recommendations at all, calling up for mimicking and for the replication of our system. But each country has its own history, its own set of circumstances, and my co-speakers here in this room have already mentioned that this day was very rich with impressions, and in the area, in the topic we discussed today, we can see certain very interesting aspects. So today I would like to explain to you what we do in the context of notarial certification about the sales contracts, because actually it will demonstrate to you how the legal structures operate in Germany, how they are built, and you might extract something useful for you from my presentation to be used in your circumstances. First of all, notaries in Germany are independent. They are free individuals. They, at the same time, carry out a public function. They work and they are commissioned by the state in their work. We are saying that this is free justice system, and the cadasters are in the basis of their work. When we work with the land plots, we very much rely on cadasters. Otherwise, the situation in Germany would have been much more difficult, and our work would have easily turned into a nightmare. There's something for you to know, because actually the cadasters reflect practically everything that has happened to this or that plot of land and other objects of property. What is in cadaster is believed to be right forever. But there are exceptions, of course, and if somebody contests these rules, we'll have to prove the opposite. Cadaster is believed to be the basis of this work with the land plots. Cadaster is sort of an internal set of regulations, and the cadaster is defines the physically established boundaries of the plots of land and all the changes that might occur. All the changes are also registered and They are actually applied as arctants in the law enforcement sphere. Since 1887, we've had cadasters in Germany, and Mr. Ivanov said that there is a very serious problem with cadasters in Russia, and there are plans to have a trade register following the British example. It's a new idea, and I don't think there is time at the moment to compare the systems, but the only thing I can say at the moment is that working with the trade registers, English trade registers, we notaries under conditions of globalization work more and more often with foreign investors. And well, of course, we at the notariate we have an opinion that a notary draws this transaction and with unlimited Gesellschaft, you can find in the internet all the pertaining information. You can actually pay with your credit card just a small amount of money to get a document from the register with the information that you have been asking for. Now, Britain does not approve that because they believe the access to all the data is too easy, and it's very difficult to identify the person who actually requests the information. So, if we look at this in a practical context, we should also say, of course, that you must be very careful when doing that, and when you have this very open and accessible register for everyone. Now, on the slide, you can find how the land plot is transferred from one owner to another. I have just said that this a plot is registered in the cadastre. Well, in Russia, it's probably done differently. And our counterpart here spoke about the right for development and about the property land and the right for rent. But, well, the property right is registered in the respective registry, and it's for 9 to 10 years, and it is believed that over this period of time the building exists. And this inherited right to develop ensures the existence of the property, which can be sold, which can be pledged, and can be associated with other burdens. And when the term expires, that's 99 years, then the plot of land is there, of course, and the owner has the right to build and to develop. Now, in Germany, in the 1990s, this rule worked very well, because in those days we had a problem after the unification of Germany, and when the new federal lands became part of Federal Republic of Germany, really we did not understand how to go about these plots of land. And my suggestion, I think, is just charming. Lawyers sometimes dwell in imagination and fantasy. And the sales contract, that's another topic, which is quite a dry topic indeed. Let's assume we have a buyer, we have a seller. Show the slide, please. And so someone owns a plot of land. The buyer wants to buy it. The buyer doesn't have enough money for that. Happens only too often. They will have some money. That's my own money. And I want to borrow money from a bank. So, on the one hand, there is a selling entity, then there is the bank, there is a loan agreement, and the loan is to be paid back, of course, and then there is the selling entity or individual. You can see how it all happens. You can see that the buyer has a debt, and there are other obligations as well, and the banks are both represented here. Just imagine there is a problem. How should all this work? The bank of the buyer tells the seller that it wants to have mortgage registered in the land book. And this seller says that it's necessary to help the buyer with the registration of this mortgage debt.
Or we have to wait while he pays back the loan. It's a wonderful phenomenon. Blue color is for the mortgage debt. He has a warranty. This loan is fixed as a security, and you have the letter of attorney to use this land plot. It's a loan. It is registered in and then you have the relations where you have collateral for this loan, and the next moment, as Professor Pruting has mentioned it already, this preeminent input into cadastre. Once you have it written down into cadastre, you cannot change anything. The following entries in cadastre can be made only in a case of the seller's insolvency or transaction declared void. So once you have an entry in a cadastre, it is as secure as English banks. But today we can say that English banks are less secure than this entry we have in our German cadastre. We have a buyer or a seller, an owner. We have his rights and mortgage security. Let's talk about the money. The bank that buys and the buyer can start paying the money. What do they do? And this is when the notary comes at play. He certifies the contract, the sales contract. He certifies the debt, and he certifies the entry into cadastre. Simultaneously, he turns to banks of the buyer. He writes to them, writes a letter to them, asking for the right to remove the entry. Give me the right, a document which allows me to terminate the debt. It only it is only valid when you have an additional guarantee. In fact, it means that you have a document to remove this debt in case I get a certain sum of money transferred to my account. This is the idea behind this operation. And the notary sends this letter to the buyer's bank and give 1,000 euros to the bank of seller, and this is how you pay back the loan, and the notary can remove the entry about the debt. And thus, eventually, this entry is removed, this collateral is removed from the cadastre. This burden, sorry, is removed from the cadastre. And after this entry, you have a next entry. So it is all fixed, it is all entered into the cadastre. You remove the debts, and they are replaced by the next debts to come. The next slide, the next picture. You have repaid your debt. Both sellers' banks are not here. We can remove the entries. And in the bottom you have the buyer, who is an owner of property. And you only have a debt secured by pledge. The notary can now certify this deal, this transaction. And this is how it happens in Germany when notary works with a sales contract. We find it to be secure. We don't need any guarantees. Let us get to France, where in every sales contract the whole sum is transferred to the notary. According to the French law, property is transferred together with a contract. The French notary, you only meet at the notary only after you have transferred the money to the notary, the money that you're going to put into the contract. Otherwise, the notary will lose his money if he certifies this contract. After he has the money, he sees the money transferred, he will be able to then transfer it to the seller's bank. It's a bit different, but the documents and the documents exchange is somewhat similar to what we have in Germany. So notary kind of needs this money to be secured to certify a transaction. I was happy to listen to Mr. Plutin, who loves those abstract things. I'm talking about this, grassroots practice. But for over 35 years, I've been happy with working in the field. Thank you very much for inviting me to this forum. My name is Andreas Luko, and I represent an organization of Association of German Banks, which issue mortgages, real estate mortgages, and we'll talk about this, field work, field legal work, or go even lower to a lower level. I would like to talk about practice, everyday activities. And since I work with foreign colleagues, I would like to talk not only about Russia and Germany, but also mention other countries as well. We find it very important that we can use real estate or immovables when providing loans. Real estate is a very important part of national economy, and the fact that we can use it when issuing loans is very important. A bank does not need to use its own assets. If we look at credit requirement regulations and new European directives for the banks, if we look at these regulations, we'll see that we can use real estate or immovables to issue loans only if you can get rid of it fast enough. If you have a mortgage pledge, you cannot take it into consideration when considering risks when you work with the banks. But you need to you must be aware that this mortgage law exists, and you need to know about its existence, and you have to be aware of that. Other banks want to know what kind of burden they will have for this real estate, how it will be burdened. So working with land plots and real estate is important for all the banks, and the question is who keeps the cadastre. In Germany, courts keep cadastre, or those land registers, and and they are independent. In some countries, there are some other independent organizations. In some countries, you have general, governmental bodies. We're happy in Germany for the courts being in charge of the cadastres, and they they make it easier for the Ministry of Finance. So Ministry of Finance doesn't have to deal with the cadastre. We had a research project, a roundtable on mortgage in Europe, flexibility, efficiency. We invited leading experts from 36 countries for this to participate in this roundtable discussion, where we discussed various issues connected with mortgages and see what the trends are. We had about 130 questions to discuss on insolvency, on rights, execution of various rights, on mortgages. We had several dozens of seminars. We discussed the development rights and building tenancy. I can recommend our documents. This is how it looked like in the year 2012, but you can see the different kinds of rights different countries would have, and you can use our website, which will be mentioned on one of the slides. This data was used by the banks who deal in mortgages, so it's very trustworthy. I mean, you can trust this data. And I would also like to point out the notary's role. The banks need mortgage and the mortgage right to be executed fast and effectively. There are cases where you don't need a notary. Those mortgage rights are part of are entered into cadastre. In some countries, you have separate cadastres for these cases, for mortgage cases. The question is, why would you need a notary? You see that you need notaries, for example, in the countries that are painted black on a map, or orange, like England or Nordic countries. They don't have notaries, or at least they do not certify land plot deals or transactions. In the countries painted green, they are not used on a regular basis. They're not on a regular basis. In the blue countries, they're used seldom. In countries painted red, only the parties can the parties can only do it through a notary. Notary is an advantage because he can assess a transaction, see whether it has been prepared in the right and the proper way. When you ask a question, how does the owner expresses his opinion on the transaction, or says he affirms the transaction in the countries painted black, you only need notary papers. Or like in Switzerland, you need documents from other bodies. In many countries, to confirm the deal. In some countries, you need documents from the bank, from lawyers. In England and the UK, you don't have notaries. You have a process of have a phenomenon of mortgage fraud when people obtain mortgage rights for other land plots, and they pay themselves and disappear. If they had an independent institution like the notaries, these frauds would not have been possible. Besides, some cadasters, some land cadasters only include documents, not rights. You don't enter rights into these cadasters. And since last year, almost everything has been mentioned in this book. It also includes various rights that different organizations have for various plots, land plots. But if they have conflicts, only the land cadaster has the dominating right. In some countries, the situation is different. In the United States, for example, all the entries in cadastre are insured. Of course, it demands. It provides a demand for insurance costs. If you have to insure an entry in cadastre, this is one of the functions that a notary has. He has to identify the right owner. We have very few cases when somebody else is acting on behalf of the owner. Notary checks all the contracts and the documents. We need to make sure that all the necessary documents are here. In the U.S., it's a big problem because they can never decide which documents should be provided. And they are obliged to provide the documents. If they had a notary, the bank wouldn't have to study these documents. And in complex cases, when you have many rights, this is where notary becomes very important, because he has to coordinate his work with other sources. If you want to know whether cadastre is efficient or not, it should defend information. The information should be secured. It should be right, and you don't need to do further research because everything you need is in the cadastre. Unlike in other countries, in Germany, everything you need is registered in the cadastre. And at this stage, the notaries act like filters of information, of cadastre information, and land books information. What is also very important, if you we can see what kind of burdens we have, what kind of property relations we have, whether information is registered in the land book. We know that in Russia, starting from the 1st of October, you have some novelties in law. whether this information can be quickly accessed. You have electronic land books. You can well, look at Belgium and some other countries, at Scotland, in Denmark. A situation is as follows. You can enter changes into land books electronically. We've seen how it looks like in Ontario, in Japan. We have compared all these countries and the systems in these countries. What is also very important for a bank is that the burden and the ownership rights can be cleared out, can be cleared. It would be great if you had it in one source. But in any case, you can find out what the burden is, and for the bank it's essential.
And then, to speed up the process in the system, how many days or weeks we need for that? That is a different procedure in different countries. In Germany, that might last for a certain period of time. With the introduction of electronic books, the process was speeding up radically, and you can see Ireland here. The island in Ireland, that is a longer process because they're introducing an electronic book, land book, and that might proceed in different ways. So I pass on to other matters. The unified opinion of the parties when concluding such a contract. What is important when delegating the law of the proper right of ownership, you have to introduce relevant changes in the land book and make a certain entry into the cadastre. That is quite interesting, and undoubtedly in Germany you have to make a new entry into the register, and in other countries, in Switzerland and Sweden, it is not necessary. You might make it on a fiduciary basis. And similarly, we have a similar situation with transferring of the property rights and actions in respect of the third parties. Most of the countries are shown in black here, and here we might proceed from what is shown in blue. This is a different category of the countries, and similarly the confidence of the buyer is ensured by the entry that is made, and for the legislator that is a very difficult situation. It is important for him on the one hand so that the turnover and the document turnover would speed up, that would become operational. In Germany, this principle of making entries to the benefit of the buyer can be contested against. As to Scotland, they say what is written in the land book complies with the right of ownership, and in the UK there are certain statements which state that for the bank who should proceed from that the collateral law applies. We have to determine whether this law is available, and sometimes the pledge law passes from the owner. Mortgage right passes from the person who is the holder of that right, and many countries take other decisions. If a wrong owner is indicated, and to him the land plot belongs, but the right of ownership is disposed by another person. In the UK, we would say that if it is a bank, you have to clarify everything for yourself. For the German bank, the situation is different, and we proceed from the information in the register and cadaster, similar to Russia. And for the third parties, it is also important that sometimes is buying the land plot. I don't mean the bank, but a simple buyer, and he cannot see from the cadaster who is the owner if there is a mistake. And that is the reverse side of that medal of that principle. And further, in this connection, the following question is also important. If anyone who is entered as a person who holds the rights into the register, and primarily we mean protection of the interests of the third parties, and in Germany that is primarily the buyer, and the reliability of the general system as a decisive factors, and the presence of a notary when effecting a transaction is also important. Recently in Scotland there was a case when fraudulent documents were issued, and the owner himself said that I will bring these documents to the bank, stating that the credit has been repaid, and I will transfer them to the bank. That also has its own disadvantages, because the second or third bank might emerge, which should never happen, and at the end for the bank it is important to start the proceedings in respect of that ownership. In Germany, for that proceeding, the decisive factor is that the notary in a certain way has recorded certain property relations. In France and in the UK, we have a similar situation, and the notarial certification of such documents is mandatory. In the countries where there are no notaries, a different solution will be taken. For instance, in Norway, you can exercise these rights without such documentary support. And then how this clause should be implemented. In Germany, that always goes via a notary, and the central position of the notary in these proceedings is quite obvious. The notary is checking and certifying all the documents and represents the interests of the consumer or the buyer. This is a mirror reflection of the situation, what is happening in the interests of the bank and in the interests of the holder of the property. When these rights are established and the holding of these rights is stated. Thus, for us, the involvement of the notary gives additional confidence. There are lesser numbers of debates related to the ownership because the notary is checking everything, so that situation becomes better for the banks and for the parties to the transaction. That means that the notary assumes that function of checking that results in effective proceedings and following the transactions, and the interests of all the parties are represented, and the turnover of the land plots speeds up and becomes more effective. Thank you. No microphone was used. Censorship, the Center of Private Law. I would like to shorten my presentation, and I'll remove 2 of the pages right now. That was a joke. That was our agenda. I would like to give some information concerning the matter that might concern the development of the Institute of the Property Rights that was carried out at the center, or probably not, because the outcome of the work is not quite clear. I'm discussing the work which is not familiar to you. I mean the concept, not the concept on the basis of which the draft changes to the civil code were prepared, by the concept of improvement of legislation in the terms of determining the features of regulating the relations related to the use of land plots and forest plots for location reconstruction and repairs of infrastructural objects. So this is the concept. We mean only infrastructural objects or linear objects. This concept was developed on the order of one infrastructural monopolies. We have several monopolies. It is noteworthy that according to the notions of the monopoly and its specialists who formulated the assignment on the concept development, the burden of normative regulation of improvement of the legislation should be delegated to public regulation up to introduction of the norms of providing assistance to the owner of the infrastructural objects when operating such linear objects on the land plots belonging to someone else. We have said that we are the center of private law, so we're going to develop the concept not on reforming the legislation, but on servitude. We immediately stated why servitude, because the relevant variety or communal servitude is contained in the draft of civil code reformation, and it is intended for these purposes. It is available in the current civil code under Article 74. Operation of linear objects might be determined by the servitude, so we frankly said that the situation will proceed in this way. So what are the prerequisites from which we proceeded? They didn't relieve us of the necessity of analyzing everything that was available in respect of regulation or laws in that sphere at present, and in the course of such analysis we investigated the following matters. One of the matters was acquisition, a possible acquisition of land plots as ownership for laying and operation of linear objects. I mean owners of infrastructure of that line object. There are 2 challenges. First, whether we need it. Most likely we don't need it, because if we mean pipelines or cable lines, cables or underground cables, whatever, in any case, the location of such facilities on land plots doesn't exhaust the entire useful properties of the land plot. So the right of ownership to the owner of the linear object is not necessary. Secondly, there is a question of the price. We have the paid principle when using land, and lately you know how the cadastre evaluation was growing. As for the price of the land, in the land code it is stated that according to the market price, but not less than the cadaster. But the cadaster price might be higher than the market one. So if we buy it as ownership, all the tariffs for the services of natural monopolies will be too high. And there is another problem with rebuying, buying from the private owner, direct purchasing, and the customers formulated the task of considering such a possibility. But we have to recognize that we have not found the possibility of making a private owner sell his land plot to another private owner, though in the law that is currently being considered by the State Duma, to simplifying the procedure of withdrawal of land plots for the municipal needs. They have approached this problem. So practically we mean that on the application of the listed persons, the owner will have to sell his land plot to the monopolist. As for this coercive purchasing, we presume that this model should not be available in the law. As to the public owner or purchasing from the public owner due to privatization of the lands covered by immovable property, the question is again the price. As to the question under Article 36 concerning the coercion to sell, however, the price is high. And the second possibility of acquisition of the rights to land, which was considered by us, is concluding the lease contract on the land plot. As to the leasing of the land plot, our colleagues have already been said that we have idealized the leasing, and it has certain features of the permanent right. But I would like to address Article 136 of the Civil Code and the new wording. And it has been amended in the following way. Previously it was written that the products and revenues from using the object belong to the legal owner, and now it is written that they belong to the owner. If we apply Articles 263 to this article that states the acquisition of property rights if we sum up these articles and read, I think that the lessee will not be able to acquire the property right for the immovable property or built on the land plot, because Article 263, he can buy it if it is not provided by the contract law. I have only one law, 214, when those who have shares of their partners become owners in the initial order, owners of their partners without any relation to the land. If it is really the case, if we read these articles together, the lessee has no right to get the right of ownership. In this sense, in certain laws on our natural monopolies, it is stated that the owners are given. They are private owners, but it is stated that this joint stock company is an owner. We cannot allow this contradiction, such as the rent as the grounds for using someone else's land for linear objects. And, for instance, the law discusses infrastructural monopolies, stating that they are owners, and in the civil law no right of ownership will be acquired. So we said that rent is also not suitable based on these grounds. And rent, I will refer to what I have heard participating in the working groups on preparation of the draft amendments to the civil law. It is not written anywhere, but it was said that Article 617 will be amended in a foreseeable future. Probably it will have to be changed. If it is the case, then the owner of the immovable property will have to solve the problem related to these amendments. For instance, the owner of the pipe or the owner of the cable line will have to solve the problem with the new owner of the land plot, and simple sales will just shock such rent which is not suitable. I'm saying, well, we provided such grounds for our customers, stating that no rent would be adequate for them. And we have instability in terms of determining the rent and impossibility of increasing it infinitely, and those periodic payments and the tariffs might grow. That is not desirable. And our customers answered that we have title-less ownership at now, and we feel quite well. It is based, as you know, on the provisions of the land legislation, which states that many years ago, and the current land code states that land plots for the needs of laying linear objects without withdrawal from their current landowner are provided for laying, and after recultivation has to be made, and that will be okay. And even our modern land legislation stresses it, and our customer says that I am quite comfortable with it, and we might remain at this stage. And we're asking them, what should we do when you need to go to the land plot and the owner would not allow? Yes, sometimes these things happen.
And actually the owner shoots at machines, so they should. So that's a problem, and the problem must be solved somehow. So subjective right to approach one's own pipe or the cable line or some sort of another linear object does not exist. So as I said, as you all know, we said that in this case the servitude is needed, and that's how we should settle the matter. With the servitude and the payment. Now again, you know, there are two models, and one installment payments or a lump sum. Well, for the monopolies, this is a very important thing, that let it be a lump sum to avoid the increase of tariffs. And as compared to the buying out, when the plot of land is in question, then the market price is to be paid. But when there is a lump sum for the servitude, then it's not the market price we're dealing with. It's definitely a small amount, and if it is a small amount, then it's going to have such a disastrous impact on the tariffs. Periodical payments are also possible, but there is I believe that if there are periodical payments for the servitude, then there is always a wish of the owner encumbered to increase the rate, and this is something that should not be permitted. So the economic efficiency of servitude in this sense is proven. So that's correct to apply servitude. So I do not really know what we're going to end with in the process, but this particular proposal that we are drafting in the process of our legislative work is the second one. It's an address, actually, a statement. A couple of years ago, another infrastructural monopoly came to us with a similar request, and this definitely makes us see that the problem is there, and that with the title and the protected areas, we do have certain issues to settle. In the future, the suggested regulation in the form of servitude might be introduced, and the owners of these infrastructural sites will have their subjective right, which can be established, can be enforced actually in Article 74. We have this particular provision. If there is no other possibility of providing a way to make use of someone else's facility or site. And the Russian legislation might amend, and thank you for your attention. We have about 10 minutes for discussion. Now you're welcome with your questions now. Brief questions and brief answers. Microphone, please. Interpreters cannot hear. The microphone is not on. Here is what we have. We have not even agreed on the final option. But, well, in the concept of the civil code, you will read that there can be a presumption for old sites and old facilities. While in the Soviet days, we were getting a plot of land with a certain facility on it, and in 99% of cases they do exist there. There are not that many that are under construction. So accepting this plot of land on the basis of long-term rent, in most cases, I agreed with the fact of the existence of that particular facility. Now, we presume that both parties agree to this particular charge. And as for the newly built facilities or buildings, there is no administrative order at all. The servitude contains a possibility of enforcement through court. And if there is agreement, that's one thing. Of course, if the agreement is not reached, then we go through court. Now, that's exactly what they were saying, that it's not effective and efficient enough. Use the microphone. I'm saying, yes, I'm saying that this is not an efficient method at all. There is an example of the new Moscow servitude, which are enforced. And then agreements can be reached on price and on other matters. Now, I didn't mention this, of course, but you can read all this is contained in my text. But it's said here that we try to develop a concept that is not limited by any particular area. Although we worked on the commission of one of the monopolies, we wanted to avoid any sort of boundaries. We really wanted our approach to work for the whole of the civil code. And we didn't want to repeat the law, the experience with the Sochi law, with the World Football Cup. These exceptions actually destroy the legislation, we think. No? Other questions? The same problem, the microphone. Good afternoon. No, we looked at a situation when servitude is established in the interests of the organizations that have to make use of someone else's plot of land. But let's look at a situation when on a plot of land, let's say there is a railroad, or there are some electrical grids. So the servitude can protect the interests of the owner of this land. Now, it's the question for the future. But actually, this particular right was envisaged. Now, it reads now that a servitude is established at the request of the interested party. The interested party is the owner of the prevailing site, prevailing object. But considering the specifics, it is assumed that, theoretically, it is assumed in our heads, of course, that the owner of the encumbered plot of land should have the same right, because the plot of land is being used and there is no legal provision regulating that. So this must be assumed. Anything else? No more questions? Then allow me to say a couple of words to conclude. I think that our discussion was useful. We compared two legal systems, German and Russian. We were able to see that the system in Germany works in a stable and reliable way. And obviously, that's how we should proceed in the future. Do you have any objections to that? That's one thing. And for that, we must make sure that the property law is discussed by the Duma and develops into a law, so that many of the issues we discussed today could find their resolution. Providing for the security of the property rights and creating conditions for better attraction of investments into property. And of course also in order to overcome the corruption that we are only too well aware of, that is associated with land, with plots of land, with the contracts and their execution. So I think we should thank all the speakers. Thank you very much. And just with this discussion on the agenda, we should have good grounds to come, not to mention the concert we listened to yesterday. And I would like to thank all the participants and the audience. We understand that property is the main value, and those who are still with us here represent the main value in the process of our discussion. So thank you very much for being immovable for a while. Now, thank you once again. We're free to go. Thank you.